to present Andreia Calcada. She will talk about the Brazilian parental alienation law. Andreia Calcada is a clinical and forensic psychologist, expert of the Court of Justice of the State of Rio de Janeiro, Brazil, in family courts and forensic technical assistant in family and criminal courts throughout Brazil. Master in Conflict Resolution System from the Federal University Lomas de Zamora in Argentina, author of books and articles in the forensic area, co-author of the first book in Brazil of false accusations of sexual abuse in family contexts in 2001, author of the book Irreparable Losses, Parental Alienation, False Accusations of Sexual Abuse, already in its third edition, member of the Brazilian Institute of Family Law. Andreia Calcada, please, you have your words. She is online, and I will ask to share the video.
Hello, everybody. It's a pleasure to be here with you all, sharing knowledge. My name is Alexandra Ullman. I'm a psychologist and a lawyer, and we are here to talk a little bit about the development and use of parental alienation law in Brazil.
Hello, I'm Andreia Calcada. I'm a clinical and legal psychologist, a speaker, a writer about these themes, and legal expert in the Court of Rio de Janeiro, especially family courts and criminal courts. Okay, about the facts. To a better comprehension, as we have only a few minutes to speak of such an important theme, we prefer to put in topics for better comprehension. And as we have a lot of content in our slides, we will summarize them in those topics. For 13 years, we have in Brazil a law that protects children and adolescents of acts of parental alienation, what means that any parent can be excluded of their lives. When judges start to apply the law and punishes who practice this kind of act against the children, some organizations try to spread incorrect information and repeal the law, wrongly using the media to do this. These kind of acts are considered in Brazil as child abuse. So when there is a punishment for such behavior, it starts the claim against the law. The most important thing to know is that the parental alienation law was created to defend the rights of children to coexist with their father and mother and their families. The parental alienation law was an achievement of several associations of parents and professionals that, since the year 2000 discussed the subject, even without being aware of the term parental alienation. From the years 2005 and 2006, the denomination parental alienation appeared in Brazil, imported from the USA. Richard Gardner, an American psychiatrist, coined the term parental alienation syndrome in 1980, based on the care of families undergo evaluation in the psychiatric forensic context. You all must know that. It's important to note that Brazilian law does not import the Gardnerian theory in a complete or uncritical form. For example, the term syndrome was not imported.
For instance, shortly after the enactment of the PA law, another one was approved in Brazil with the intention of maintaining parental equality between fathers and mothers, the shared custody law in 2014. Far from being the solution, the law brought within the necessary change in standards for parental pairs to reorganize themselves. The world has been changing at high speed. Women entered the job market and men began to work more at home and taking care of their children. Necessary and fundamental change for the establishment of a positive co-parenting that only brings benefits to the children involved. Legislative, historical, and social changes in the role of the family are reflecting the new validation of the father in the scenario of Brazilian laws. This validation brought practical changes, such as the increase in disputes at the request of male parents in an attempt to validate their role as fathers. As a result, mothers who most often had custody of their children began to refuse to recognize this change, programming their children to align themselves with them in the legal battle. Time is the greatest ally of the parent who commits alienation.
So, a lot has changed. The status quo has been destabilized. It's not surprising that movements make a counter-reaction in an attempt to maintain the hegemony of their power before the offspring, currently threatened, aiming to set back this process in the country. The law brought about many changes, both in the mentality of families and in the judiciary. The term and the concept of parental alienation were gradually disseminated among professionals. Today, especially in large centers, professionals seek to update and expand their training in identifying signs of parental alienation, as in case of psychologists and social workers, and in legal positioning, aiming to safeguard the relationship between parents and children, protecting the latter.
Parenting is the exercise of responsibility that imposes rights and duties to parents to care for their children, such as education, housing, leisure, physical, psychological, emotional, and spiritual safety. The 13 years of the parental alienation law brought advance search for solutions. Mistakes, yes, there are, in search of successes, but that is how development works. They brought the incessant movement to bring knowledge about the subject to professionals, whether they are legal practitioners or not. And along this journey, the movement of mothers who claim to be wronged arises. Mothers who claim to have lost custody of their children after having denounced their parents, former partners, or of sexual abuse. They accuse the psychological expertise carried out of being partial, analyzing children by handing them over the pedophiles who hide behind the law. They accuse the law of being based on supposedly discredited research by Richard Gordon. In the previous social and legal scenario, the practice in the court showed the impossibility of considering the possibility of unilateral custody being granted to the father. The idea more firmly existed that mothers, because they were women, were intrinsically superior to men in raising children. However, this criterion was found to be contrary to public policy, which strives to treat the sexes equally.
It was also stated that the tendency is for there to be more and more balance between the genders that practice parental alienation or of their children, as fathers, men, start to enjoy more interaction with their offspring. It's important to point out that parental alienation is not a gender issue, but a cultural one. As previously mentioned, since until recently, custody was still unilaterally granted to mothers. This was then a power relationship, as it is shown now, the power struggle for the repeal of the law in the way it has been done, irresponsible, with accusations without any basis, and emotional appeals of the alleged helplessness of the child to be handed over the supposed abuser. That is, it will become increasingly clear that this is not a discussion about the gender issue, but about the child, to the extent that laws and judicial practice balance parental roles. The focus of discussion will be the child, no matter which parent or whether both practice this form of psychological abuse. The law has a pedagogical function in the sense of informing and curbing abusive practices. There are several reasons why a child may reject their loved one. It may be that they have actually been abused, mistreated, etc. Or it may be that this rejection is artificially induced, as in the case with parental alienation. The constant need for training is a subject that is much discussed among professionals, since failures are still observed. The expert psychologist or social worker must follow the provisions of paragraph 5 of the law on parental alienation to comprehensively address the topic to be investigated.
So there were many battles until the conquest of the law. Attentive eyes from law operators and interdisciplinary teams led to the vast necessary jurisprudence that served as the motivation for the formation of the law in force. Between the existence of the law and its application, there is a distance permitted by evidence and studies, in addition to the involvement of several professionals committed to protecting the rights and guarantees of children and adolescents. These are the target of the law, not the parents, as they try to believe. As can be seen, the group that today seeks the repeal of the law is formed, for the most part, by parents who had custody of their children reduced or transferred to the other parent. It is important to understand how this happened. As demonstrated in this work, these cases are rare and could only occur in the face of serious facts, proven in the case file. No judge will remove children from one of their parents simply out of sympathy for the other. This would be to state that Brazil just simply does not exist, which is not the case. There are flaws in the justice system, as in all segments, but in general terms, we have a functional, serious justice respected by the Brazilian population. Differentiate real abuse from false accusations is the role of the multidisciplinary, specialized, and trained team. Parental dysfunction must be the object of evaluation and treatment, which incidentally is already provided for in the child and adolescent statute. Irresponsible movements with little foundation and poor technical scientific knowledge must be curbed under the risk of jeopardizing the clear evolution felt and experienced over the years in Brazilian society and legislation. Parental alienation is a public health issue, and undoubtedly, the law does not need questioning, but improvement in the mechanisms of attention and care for children and adolescents, victims of parental alienation, in the legal structure that supports it, and continued training of law operators for its proper use. Law, the parental alienation law, is an instrument for the protection of children and adolescents. Thank you.
Thank you for all.